Disputes involving prosecution for criminal offences, disputes affecting the rights of third parties to the mediation, any matters under the jurisdiction of the National Tribunal, any dispute in relation to direct or indirect taxation, any disputes under the Competition Act, Telecom Regulatory Authority of India, the Petroleum and Natural Gas Regulatory Body, proceedings before SEBI and SAT, land acquisition, determination of compensation in land acquisition laws, or any provisions of law providing for land acquisition. So these are the matters which cannot be referred to mediation. Of course, then there is something called Mediation Council of India. While there is a provision in place, Mediation Council of India has not come into effect yet. It has not been set up, but it does. The Act does provide how it is established, what is the composition, what its role is. So that's very clear in the Act. But I just wanted to give you a brief view that there is this provision which will come into effect sooner or later, where there will be a body which will be created, which will then supervise in that sense the mediations across. Some of the few prominent features of the Act. Mediation Service Providers, Section 3M. The Act provides for mediation service provider as defined under Section 2M to administer mediation proceedings between the parties under Section 448. The mediation service provider should include a body or an organization that provides for conduct of mediation under this Act and the rules regulations made thereunder, which is recognized by the Mediation Council of India. Moreover, under Section 40B, 40C, an authority under the Legal Services Authorities Act, the court connects mediation centers. So when you go in for a mediation, the first stage is introduction and opening statement by the parties and the mediator. At this stage, the ground rules and the features of the mediation sessions are laid out as to how the mediation will proceed, what opportunities who will be spoken to, whether the mediator will first speak to both parties or whether will he first want to hear each party separately and then sit with both of them together. So he will kind of set the procedure in place. Generally, this second stage is where the joint sessions take place, where both parties say what their issues are in front of each other in the presence of the mediator. Then the mediator also takes another next stage, where the mediator sits with each parties and tries to listen to their issues, narrow down the issues, and see if the matters can be resolved or not. And of course, at the end, if there is a settlement, then parties will enter into a settlement and the mediator will approve it. It's called the mediated settlement agreement. If parties do not agree and are not agreeable to entering into a settlement, whatever was discussed in the mediation will remain confidential and cannot be used in court proceedings, and the parties are free to go back to either court or arbitration. Role of a mediator, as I have already said, role of a mediator is that more of a facilitator than that of an adjudicator. The mediator creates a conducive environment to facilitate communication, identify interests, and guide discussion to help parties to generate options, overcome obstacles, to reach a mutually acceptable settlement. The mediator evaluates rules, involves guiding parties to really testing and assessing their cases and helping them evaluate settlement options. Qualities of a mediator. The mediator must possess qualities like genuineness in the entire process. He himself should believe in the process of mediation. He should have skills to bring parties to talk. He should be in a position to ensure that parties are able to talk to each other rather than they just sitting and fighting with each other. Help them understand the sensitivities of the matter, sensitivities of the parties. In many mediations, we've seen there are cultural differences. So it's also to understand the cultural differences. People come from different walks of life. People come from different countries. Everybody has different cultures. What is good for you may not be good for somebody else. The mediator may be from a third culture. He may understand a culture in a different way. So it's very important that he understands what the cultures of each parties before him are. Because what he thinks is right may not be right for the other. So it's very important that culturally also the mediator attunes himself to the parties. While in Salem Advocate Bar Association, there are some broad guidelines given about who the mediators should be and what their qualifications are. But these are just a guideline and more of a observation in the judgment. That's why I have just listed some of the things here to say that about legal practitioners with 15 years of plus experience, experts or senior professionals with 15 years plus standing and recognized expert institution approved by the High Court. But this is not all the criteria. To my mind, you must also train yourself as a mediator because it's very important to understand how the process works, and therefore it's very, very important that you take a mediation training, and many institutions across India and abroad are actually giving you the mediation trainings. As I said, the role of the lawyer in mediation is the most critical role because it's for him to have first believed in the process, understood the process, encouraged the clients to use the process in an effective manner rather than just a tick box approach. To use the entire process to see that if he can get his matters resolved and not just say that, okay, this is a way to buy time. No, it should not be treated that way. The mindset has to change. People still consider that, okay, if I want to avoid an injunction, I'll go for a mediation, I'll buy time, I'll delay the hearing. But I think that's gone are those days. I think the way we are and the way the world is moving towards to resolve matters and move quickly. Finish one matter today, you'll get two more tomorrow. Don't stick on to the one matter. Of course, then there is a mandatory pre-institution mediation in the Commercial Courts Act. As you all must be aware, Chapter 3A was inserted into the Commercial Courts Act through the Commercial Court Amendment Act 2018, which introduced Section 12A to the Commercial Courts Act. Section 12A provides that a suit which does not contemplate any urgent interim reliefs under the Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation. But yes.
And welcome to Goa for this wonderful morning and hosting a 3 days activity. So I would like Mr. Parida to give a welcome note to the participants and the faculty member. I would
on behalf of the Goa High Court Bar Association and the organizers, the ICS, I extend a warm welcome to all the participants in this 3 days certified training course on domestic and international commercial arbitration, jointly being organized by ICS and the Goa High Court Bar Association. I extend my warm welcome especially to people, to my colleagues who have come all the way from different parts of the country and are here to impart you this training, especially Mr. Ganesh Chandru, partner in dispute resolution, law associate, whose expertise spans the intricacies of arbitration across diverse jurisdictions. Mr. Veera Raghavan, a distinguished fellow of the Chartered Institute of Arbitrators UK and governing body member of the Indian Council of Arbitration, whose contribution to institutional arbitration are unparalleled. Mr. Raj Panchmatia, partner of Ketan and Company, with whom also I have been associated in the past, renowned for his deep understanding of dispute resolution and cross-border arbitration, and to Mr. Amit Meharia, managing partner at MCO Legal, whose commitment to advancing arbitration practice has left a significant mark on legal fraternity. I must express my gratitude to to the ICA for co-partnering with Goa High Court Bar Association and accommodating 36 of our members to participate in this event. Thank you, Mr. Chawla, who is not here today, and thank you, Mr. Amit Padia, for the courtesy. I must say that the old order has changed, giving place to the new. Traditional lawsuits have proved to be not a solution in commercial disputes on the linear principles that a justice delayed is justice denied. The Arbitration Act 1948 proved to be an ineffective law for settling arbitral disputes. Munshi Tral revolutionized the dispute resolution through arbitration. That's how the Arbitration and Conciliation Act 1996 came into being in India. Yet, the Act had a lot of loopholes and was found to be ineffective for speedy resolution of commercial disputes. So the Act was amended in 2019 and in 2021. Though amended, still has certain loopholes. Section 32 of the Arbitration Act requires fine-tuning. The Managing Committee of the High Court Bar Association, keeping in view the need for creating in the state a conducive atmosphere to encourage arbitration and conciliation as a means of resolution of commercial disputes, has entered into an agreement with ICA with a mind to have Goa as a center for international arbitration. The program of today is one of the steps for encouraging dispute resolution by arbitration and conciliation. It is in this pursuit that we are here today to begin with this training program, which will be followed and pursued with ICA for many more such programs to create awareness about arbitration and conciliation as a means of settlement. I thank each and every one of you for participating in this program, and we hope we will be benefiting with it. Thank you.
To host this event, and it's been our privilege with all the support and the love being given by the bar. So I will now invite our faculty members and we give a brief introduction. Firstly, Mr. Ganesh Chandru, partner at Dua Associates, Mr. Rajpanch Matia, partner dispute resolution for Khatan and Company, Mr. Amit Meharia, partner MCO leader, and Mr. Inva Vizen, he's a FCIR and also governing board member of ICA and also head SICI Arbitration Center in Chennai. We look forward to hearing you and your vision, and it would be more of a training session, but we also take participations, feedback, their suggestions to make arbitrations as a preferred mode of dispute resolution, and also now mediation. So we'll speak more on mediation. ICA is coming out with their mediation rules, and Goa being one of the destinations which is government of India is also aiming for to set up a center. We look forward for all the valuable input which we can put across to our board and ministry at the same time. Thank you.
The other members of the Indian Council of Arbitration, the delegates, participants, and hopefully by day after tomorrow I can familiarize myself a little more with the members of the association. But at the outset, let me just express my gratitude to Indian Council of Arbitration for associating with Goa High Court Bar Association in what will be a great exposure seminar for members of the legal fraternity in Goa. we are quite well versed with the arbitration scenario, but fact remains that it's ever-changing landscape, and it is seminars like these that give us an insight into the current arbitration landscape world over, international and domestic. So I think members of our fraternity are present in large numbers. They've taken this opportunity, which by itself should be indicative of what it means to them. So once again, it's a matter of pride for us that we are associated with a distinguished organization like the Indian Council of Arbitration. Now, as far as arbitration goes, I've had the opportunity to practice for over 20 years before the tribunal, before the courts. And I have a particular point of view which I will reserve for some other seminar, because I strongly believe that a lot more needs to be done. If you see the legal jurisprudence, the lawyers have found it intellectually stimulating to argue more on the interpretation of the act than actually the subject matter of arbitration. And that comes with a strategy as well, because invariably you weigh your scales and then take these technical interpretive arguments, which according to me has to a great extent impeded the march of arbitration. Because if you see right from the repeal provision of 1996, it took a long time by the time Supreme Court settled it to conclude when arbitration commences. In the meantime, there was a lot of collateral damage. Definition of court has went through, again, despite various judges of the High Court to the Supreme Court, and it is just unending as to how every amendment, instead of being a solution, has in fact led to a problem. For people who are regularly practicing, I'm quite sure it will resonate with each one of you, because it is normally frustrating for the party who bona fide approaches an arbitral tribunal, and I'm sure everybody realizes the scales when you approach an arbitral tribunal, and then you have these arguments on interpretation of court, interpretation of when the notice of arbitration, 34, which is the lawyer's delight for so many years. So I have a particular point of view. I will leave that for the later. This is not the day. But all I will say is there needs to be a collaborative effort at the end of the legislature, at the end of the judiciary, at the end of the executive, and at the end of the stakeholders. Because eventually it is systemic. We can do all that it takes to streamline the arbitration, and I must say that ICA is doing a phenomenal job. But it needs the support legislatively from the executive. We need the funding, the backing, because the problems, the system is such in India that it is intricately linked with the courts. So the problems of the courts are problems of the arbitration. So as long as there is, I'm not saying we distance ourselves, but the point is we need to have that, as I say, a dedicated corridor, a dedicated court in various jurisdictions. It's not about a Bombay or a Delhi. I mean, if you look at a scenario in Goa, the court is the civil judge senior division. So you have the arbitral tribunals, maybe of Supreme Court judges, where the 34 goes to a civil judge senior division, 37 goes to a district court and never sees the face of the High Court. So these are systemic issues which was for a larger debate. We can do brainstorming at some point of time. But I just thought I'll introduce my thought process on this important day, where I'm sure a lot of the distinguished members are also grappling with this thought process and realize that there is only as much that we can do. But the positive note is there is a concerted effort by the stakeholders to do whatever they can, and that is where I think the Indian Council of Arbitration has, to a great extent, provided that platform, is providing that training, trying to make us ready for the future, but they will require support from all the stakeholders. Leaving that thought and parking that thought, when we have with us Honorable Justice Karnik. He had a very distinguished and a stellar academic record. He passed out from Pune University in 1991 with distinction. He joined the Bar Council of Goa and Maharashtra in 1991. He was practicing before various fora, more particularly predominantly in the Bombay High Court, for more than 25 years before he was elevated in 2016. And the key factor today is that he has a very strong commercial sense in matters, because we are talking about commercial matters. Eventually, for a High Court judge, whether it's a pension of 10,000 or commercial, you can't really have a distinction. But you would want a judge who has a holistic perspective. So in matters, he has a key commercial sense. He's got a fantastic grasp when it comes to various subjects of law. And in the context of arbitration, he delivered a landmark judgment in the case of Sheila Chowgule about a couple of months ago, where he authored the reference judgment and concluded that the court, and if an appointment is made by the High Court in 11, the court under 29A will be the High Court and not the court as defined, not the court of principal, court of original jurisdiction. So, but that debate continues. But we have really if I may say so, a very distinguished guest today who will address us, will address the gathering. May I request Honorable Justice Karnik to kindly address the gathering.
Dignitaries on the days, dignitaries of the days. In the post 5 p.m. I had thought crowd may be very feeble, but I see that all of you are very enthusiastic even after a day-long session. And I had initially thought that was a longish note in front of me. I would cut it short, but now I am encouraged to take as much time as possible. I will try to cut it short. Now, we are all aware of and I don't think I'll be speaking anything, I have anything new to offer, but the provisions of law as we normally do. But so far as the history of the arbitration in India is concerned, although not called arbitration, settling disputes was a requirement even amongst the older communities. There were disputes in respect of animals or ownership of properties, construction of house, etc. There was no formal legal framework in place, nor was there a judicial system. Therefore, the decision was conditioned by the strength of litigating party, which created imbalance in the society. Since Vedic times, arbitration has always been part of alternate dispute resolution mechanism, which included 3 distinct arbitral bodies: Huga, that is a group of persons of same locality, Sreni, the Council of Artsmen and Tradesmen connected to the profession, the Kula, a group of people belonging to one family. Over time, the 3 bodies collectively evolved into panchayats, where disputes were resolved by elders or wise men in society who acted as arbitrators. Panchayat proceedings were informal and simple as compared to the complexities of the court, and the decisions given by them were final and binding on the parties. The panchayats covered various issues ranging from marital disputes to property ownership matters and sometimes even criminal cases. During the British rule, the East India Company made several rules and regulations for resolution of disputes. The Bengal Regulation Act of 1772 became the foundation of modern arbitration law in India. It recognized legality of arbitration agreements to settle disputes through arbitration and provided a basic framework for arbitration proceedings. It was followed by the Bengal Regulation Act 1781, the Bombay Regulation Act 1789, and the Madras Regulation Act 1802, which established basic structure for arbitration. The Bengal Regulation Act 1882 is considered as the first formal legislation of arbitration in India. It provided framework for arbitration and was applicable to the Bengal presidency. It allowed settlement of disputes outside court system by arbitration, and the disputes were mainly in the nature of land, revenue, and related disputes. It provided for appointment of arbitrators for conducting arbitration proceedings and enforcement of their decisions. The Madras Regulation Act 1860 even provided for referring the disputes through the panchayats. The Indian Arbitration Act 1889 came into force on 1/7/1889. It was based on English Arbitration Act of 1889 and applied only to the presidency towns of Bengal, Calcutta and Madras. Unique features of the act was that names of the arbitrator had to be mentioned in the agreement, and the arbitrator could be amongst the sitting judges at the time. However, the 1889 Act was bulky and required reforms, which led to the passing of the Arbitration Act 1940. The Civil Procedure Code also provided for arbitration proceedings. The Indian Arbitration Act 1989, the Civil Procedure Code and the Arbitration Act 1940 boosted the dispute resolution by arbitration. Later provisions relating to arbitration were inserted in Section 89 by the Civil Procedure Code, Amendment Act 1999, which came into force after the Arbitration and Conciliation Act 1996. The Arbitration, Protocol and Convention Act 1937 was introduced to implement foreign arbitration agreements which are subject matter of Geneva Protocol and the arbitration clauses of 1923 and the Geneva Convention on the execution of foreign arbitral awards of 1927. The Act recognized and aimed to recognize foreign arbitral awards, and such recognition and enforcement helped the arbitration laws of India to be in sync with the then existing international standard. The Act provided for a structure to resolve disputes involved in international contracts through arbitration and promoted and strengthened the international business relationship. The Act ensured that India fulfills its international commitments under the Geneva Protocol Convention and promoted India's cross-border reputation and credibility in international trade and commerce. The Arbitration Act 1940 came into force on 1st July 1940. It was the first formal legislation which specifically covered an alternate dispute resolution mode in India and replaced the provisions of the Indian Arbitration Act 1889 and the provisions relating to the second schedule of the civil procedure. The Act laid down several rules and regulations regarding conduct of arbitration proceeding, which included rules on the duties and powers of arbitrators to rules and arbitration awards. However, there were several limitations and drawbacks which, amongst others, included the following. Different high courts had different rules for filing awards. If the court appointed arbitrator died during the arbitration, there was no provision for replacing the arbitrator. The scope of interference in the awards by courts was not clearly outlined, leading to matters languishing in court after arbitration for years and decades. The Foreign Awards Recognition and Enforcement Act 1961. The necessity of the said act was driven by India becoming a party to the New York Convention of Recognition and Enforcement of Foreign Arbitral Awards of 1958. It provided an enforcement mechanism for commercial arbitral awards made on or after 11/10/1960 in countries that were parties to the New York Convention or with whom India had declared reciprocal enforcement through a notification. A person interested in enforcing a foreign award could apply to a competent Indian court to have an award filed and registered, and court can order the enforcement unless certain limited grounds of refusal are established. The said act was repudiated in 1996 and the provisions were incorporated into the Arbitration and Conciliation Act 1996. In 1966, United Nations Commission of International Trade Law, the UNCITRAL as we say, was established as one of the core legal bodies of the UN in the field of international trade law. The function of UNCITRAL was to modernize the rules of international business, and its work included globally accepted conventions, model laws and rules, legal and legislative guides, and practical recommendations, up-to-date information of case laws, and uniform commercial law enactments. A model law was adopted in 1985 to meet the evolving needs of the international community. Through the model law, the UN General Assembly intended to instill robustness amongst the countries across the globe towards modernization of their respective domestic arbitration-related legal framework. It suggested enacting arbitration legislation based on model law. India was heavily influenced by the global events which led to the passing of the Arbitration Act 1996, which act was codification of the guidelines of the model law of international and commercial arbitration, with exception for a few provisions. Now, there is a note on the Arbitration and Conciliation Act 1996, which I just skipped, and straight away come to the basic features of an arbitration. The basic features of an arbitration are: it is based on consent, Consent has to be in writing in the form of contractual clause or a correspondence between the parties. The process is neutral, fair, and aligns with the principles of natural justice. The parties are free to choose neutral arbitrators, and important elements of the disputes like applicable law, the language, and the location for the arbitration. Parties can mutually appoint an arbitrator of their choice and determine the number of arbitrators provided the number is odd. The arbitration proceedings are confidential and only involve parties who participate in the proceedings. The report over the years on the efficacy of the 1996 Act highlighted the following drawbacks. Now there were several drawbacks, so I won't take you through all that. I'll straight away come to the Amendment Act of 2015, which was necessary because of the drawbacks. The said Act was amended in 2015, which amendment came into force on 23/10/2015, which modified the existing arbitration regime in the country. The basic features of the amendment, again I won't go to the basic features of the amendment which you are well aware of, but there are some judgments of the Honorable Supreme Court which necessitated certain amendments. In the case of Bharat Aluminium Company, that is 2012 9 Supreme Court cases 552, then Bhatia International and Venture Global Engineering, that is 2002, the second one is in 2008. Then the powers of arbitrator to order interim leaves were enhanced. The amendment made it mandatory that once a tribunal is constituted, an application for relief must be made only to such tribunal unless the remedy granted by the tribunal won't be efficacious. It was made to avoid a situation where applicant sits on injunctions for months but delays commencement of arbitration. The applicants must make application within 90 days of court order. The powers of arbitral tribunal to grant reliefs were made coextensive to that of the court to grant interim reliefs, and such an order was given the effect of a court order. Then there are several other matters. Then the amendment specifically bars the review on merits of the dispute while considering the ground of contravention of fundamental policy of law. There are these judgments which are landmark judgments. That is PSA, I don't have to labor much on that, all of you are aware of it. PSA Sequel Terminals Private Limited versus Board of Trustees, where the apex court held that the scope of interference in section 34 is limited and the court is not expected to act as an appellate court to or reappreciate the evidence. Then Reliance Infrastructure is one important judgment where the apex court held that the scope of jurisdiction in appeal under section 37 of the Arbitration and Conciliation Act is all the more circumscribed with reference to jurisdiction under section 34 of the Act. It made arbitration a lucrative form of alternate dispute resolution, and critical changes supporting the international arbitration within India, which were made, which are broadly indicated. I'll just indicate broadly what are those, some of them. Substantial restriction and reduction of judicial intervention, extension of provisions of Part 1 to international commercial arbitrations, even if the place for arbitration is outside India, unless the parties agree otherwise. Court was defined to mean only High Court of competent jurisdiction. The provisions of Section 9, that is interim relief, Section 27 and Section 37(1)(a) shall apply to international commercial arbitration. A strict time limit for conclusion of arbitration proceedings was imposed. The period was fixed at 12 months, with an additional 6 months extension available. The above changes were brought about to streamline and expedite the arbitration process. However, even after inclusion of several amendments, there were several issues with respect to interference of court, appointment of arbitrators, and so on and so forth. Now, on the applicability of 2015 amendment, there were conflicting decisions of the Honorable High Courts and the apex court. The case of BCCI versus Kochi Cricket Private Limited, the Supreme Court held that 2015 amendment would apply to all court proceedings pending or commenced after October 23, 2015, the date on which the 2015 amendment came into effect, whether or not they were in relation to arbitral proceedings commenced prior thereto. The important aspect of the judgment was that while prior to 2015 amendment, there was an automatic stay of enforcement of awards upon the challenge being filed, this position, the apex court made it clear that the same would be applicable even to pending application under section 34. The judgment in the case of BCCI was negated by the 2018 amendment, where it was specifically stated that the 2015 amendment would apply to arbitrations commenced after 23/10/2015 and court proceedings emanating therefrom. Amongst the most fundamental and significant amendments brought about by the 2015 Amendment Act was laying down the broad contours of eligibility to appoint eligible arbitrators to negate perceived bias. The Honorable Supreme Court in TRF Limited versus Enevo 2017 8 Supreme Court cases 377 held that a managing director of an entity or his nominee are ineligible to act as sole arbitrator. Then there is a decision in Perkins Eastman Architects which held that any person who has an interest in outcome of the dispute would be ineligible to be appointed as an arbitrator and basic principles of natural justice. Then in Block Asia Pacific Limited, the Supreme Court held, while following the ratio in TRF Limited, in respect of single member of tribunal, and has further held that Section 12(5) is also applicable to contract entered into the name of President of India. In the said judgment, the Supreme Court held that arbitration clause which authorizes the Secretary, Ministry of Home Affairs, whose relationship the Union of India is that of an employee, to nominate an officer of Ministry of Law and Justice to act as a sole arbitrator, clearly falls within the expressly ineligible category provided in Schedule 7, Para 1, read with Section 12(5) of the Act. As the grounds of challenge to the appointment of arbitrator under Section 12(5) of the Act operate, notwithstanding any prior agreement to the contrary, we cannot give effect to the appointment of an officer of Ministry of Law and Justice as an arbitrator, unquote. The above judgments have gone a long way in creating healthy arbitration environment and ensuring fairness and sanctity of the arbitration process is maintained and to ensure that the justice is not only done but seen to be done. Then comes the Amendment Act of 2019. This act was aimed at making India an arbitration-friendly jurisdiction and aligning its arbitration laws with international jurisdiction. The important features were reduced judicial intervention, appointment of arbitrators by an arbitration institution and streamlining the process, expedited appointment of arbitrators, provision for confidentiality of arbitration proceedings, provided clarification on division of responsibility between arbitration tribunal and courts for seeking interim reliefs post the arbitral award but before its enforcement. 8th schedule was introduced describing an exhaustive list of requisite qualifications and experiences for being appointed as arbitrator. It also provided for establishment of ACI by introduction of Part A to the Act and stipulated recognition of professional institutions, provided for accreditation of arbitration as one of the essential duties and functions of ACI. Arbitration Council of India 2019 amendment is expected to lay down standards, make arbitral proceedings more party-friendly and cost-effective. The ACI will grade and accredit arbitral institutions and arbitrators and trade policies for such grading and accreditation and for uniform professional standards. ACI is empowered to frame policies and guidelines for and in respect of all matters in relation to arbitration, and is also empowered to make regulations in consultation with the central government for its duties under the Act. However, the provisions relating to ACI Part 1A are to be still notified. Now, the Arbitration Order of 2020 has made a brief reference to that. That was promulgated on 4/11/2020, which aimed to address concerns raised by affected parties after enactment of Arbitration Conciliation Act 2019. The ordinance introduced amendment of Section 36(3) to provide additional grounds for an unconditional stay on enforcement only if the seat of arbitration is within India and if the court is prima facie satisfied with the arbitration agreement, which is the basis of the award, is vitiated by fraud. Then comes the Amendment Act of 2021, which replaced the ordinance and came into force on 11/5/2021 and proposed qualifications for accreditation of arbitrators to be prescribed by regulations and framed by Arbitral Council to be set up. The 2021 amendment attempts at a cleaner and more professional arbitral process and seeks to address the lacunae in the arbitration legal framework. The Amendment Act amended provisions of Section 36 and added a proviso which was in consonance with the ordinance that was promulgated on 4/11/2020. It further substituted Section 43J, which provided for norms of accreditation of arbitrator, and the 8th schedule, which dealt with qualification of arbitrator, was deleted. Now, the effect of Mediation Act 2023 on the conciliation under the Arbitration Act, I'll skip that and straight away come to one important aspect, that is the institutional arbitration. Institutional arbitration in India will have a significant role to play in the streamlining of arbitration process in Goa. I'm coming to Goa, and in order to achieve the world standards which will provide an able support of the economic growth of the country. As stated earlier, in 2019, Arbitration and Conciliation Act 1996 was amended with the intent to strengthen international arbitration with the recommendations of higher level committee chaired by retired Justice Sri Krishna. The committee was established to the institutionalization of arbitration in India. Arbitration institutions can play a key role in ensuring convenient initiation, continuation of arbitral proceedings in this digital age. The need to recognize institutional arbitration is now stronger than ever. Arbitration conducted under the aegis of an arbitral institution can have many benefits in these digital times, as arbitration tribunals can set up remote case management systems. Institutions can ensure that the matters are conducted efficiently by litigant-friendly filing and hearing process by availing of digital technology, and take into consideration convenience of the parties and the lawyers, including the time zones. Arbitration can no longer be viewed as simple and alternate mode of dispute resolutions. It is now governed by substantial procedural rules, and the entire arbitration adjudicatory process is now professionalized. It is necessary that arbitration ensures trust amongst its stakeholders while calling upon all stakeholders in the arbitration community to collectively and proactively act to secure trust in arbitration. The institutions are availing of artificial intelligence to bring in efficiency in the adjudicatory process. However, there is a need to further incorporate the technological advancement to make institutional arbitration cost-effective and make it accessible to all parties, irrespective of the financial capacity or legal sophistication. In case of international commercial agreement arbitration, the stakeholders still find comfort in turning to the international institutions, even if the seat of arbitration is in India. Despite the apparent advantages of institutional arbitration, it is seen that only 30% of arbitration in India is handled by way of institutional arbitration. There is still a preference of ad hoc arbitration, not just amongst individuals, but also amongst companies. This is in contradiction to the global trend. Institutional arbitration provides a clear set of arbitration rules and timelines for arbitration, and the supporting infrastructure and resources, including a panel of arbitrators. However, the thought process of litigants continues to be that the ad hoc arbitration gives more autonomy to parties, apart from a misconceived perception that their arbitration institutions lack credibility. Now that there is a statutory provision which provides for establishing of Arbitration Council of India to promote institutional arbitration, great institutions, accredited arbitrators, and encourage consistency by introducing countrywide policies, time has come to seriously think of notifying Part 1A of the 2019 amendment. Domestic institutions like Mumbai Center for Arbitration, the Delhi International Arbitration Center, and International Arbitration and Mediation Center have gained some credibility and are administering some high-stake arbitrations. This will be a way for robust institutional arbitration system in India. With this, I wish you all the best for the future sessions. Thank you so much.
I would like Mr. Ganesh Chandru sir to give the vote of thanks.
Honorable Justice Karnik, Mr. Pereira, Mr. Desai, friends from Goa, and all the delegates who have come from all over India to attend this training program. It's great to be here in Goa. Of course, while I'm here to propose a vote of thanks on behalf of the Indian Council of Arbitration, I'd like to on behalf of the ICA, personally thank Mr. Pereira, because this all emanated out of that conference that we had at the Marriott Hotel. Earlier this year, where I had the privilege of being one of the speakers. It was just on the stage that it was decided that we'll have a workshop in Goa. While I'm I practice law as a lawyer as well as arbitrator. When they said there's this 3-day workshop in Goa, well in advance, myself and my other faculty members, we had blocked our diaries to be here. For the very reason, just Karthik mentioned about Goa being a possible international center for arbitration. I think this is one of the best places where we can think of an arbitral institution, because certain places, when you say the name, you feel energized, you feel happy. Like you say Shimla, Uti, when you say Goa, people are very happy about it. That's a great advantage. It's a great advantage for a place, and I think this is a very good step taken by the Goa Bar Association. I should congratulate Mr. Pereira, Mr. Desai, and all your members. I think many of them also attended the program today. We have had 96 delegates. I think I've been associated with ICA training programs over the years, and this is one of the highest attendance. And I think the interactive session today, the kind of questions and the experience that the participants were sharing were very, very, very beneficial for us as the faculty members as well. My name is Ganesh Chandru. I would also like to introduce the other faculty, Mr. Imba Vijayan, Mr. Amit Maria, Raj Panchmati was left, and also Bhavik Rajani, who is also from Goa. He will be taking a session tomorrow as well. And the ICA, the Indian Council of Arbitration, has been a yeoman service to arbitration in this country. They have been conducting these workshops for several years. Mr. Amit Padi, the registrar, thank you for all your efforts. Mr. Ashok Agarwal is also one of the long-standing employees of the Indian Council of Arbitration. And Mr. Ravindra, for all the hard work. Thanks to all of you. Of course, special thanks to the Honorable Judge for taking time off. In fact, sir, when he gave me this script, he said it's too detailed. But I really didn't believe he could summarize all that within like 12 minutes or 15 minutes, which was like a refresher course of what we did today. It's a word of all the cases, be it TRF or Perkins, everything was included in the paper. And I think thanks to you, sir, for that wonderful overview of what arbitration should be, the history, and what institutional arbitration is. I think that's extremely important. We have to move from ad hoc to institutional arbitration, which, like Honorable Justice said, most of the world today is going towards institutional arbitration. And there are several institutions that are being set up in India, and hopefully we will see Goa as a great institution as well. And thanks so much to all of you for participating in this workshop. Of course, this is the first day, we have 2 more days. So with that energy and vigor, let's move and contribute to institutional arbitration. And thanks to the Bombay High Court Goa bench for giving this fantastic facility. Such a beautiful building, sir. This is the first time I've been to the old courts, which was nostalgic as well. The view of the lake and everything is just fantastic, an amazing facility. Thank you so much on behalf of the Indian Council of Arbitration, and thanks to all of you. I wish you a great rest of the 2-day course, and enjoy your evening. Thank you so much.
I am Paramita Banerjee. I am the legal head of NCO Legals. I generally look after the Calcutta and the Bombay office of ENCO. My senior, Mr. Amit Niharia, is one of the faculty, and as a result, I am also here to attend this wonderful conference that ICA has organized. So, thank you.
Good morning. I am T. Gandhi from T. Gandhi Company Chartered Accountants, founder partner in the year 1986 as established. I am a practicing chartered accountant as well as the forensic auditor and insolvency professional, and also pursuing now ICA arbitration. Thank you very much. Have a good day.
Hi, my name is Balakrishnan, coming from Bangalore. I am also an insolvency professional and a practicing chartered accountant. I focus only on insolvency matters, and I am more interested in area primarily because I feel that is the next thing to look forward for. Looking to meet you individually also. Thank you very much. Have a nice day.
I am S.P. Patnaik from Odisha, Bhubaneswar. I am retired Chief Engineer from PWD. So now I am working as Chief Advisor to Bhubaneswar Metro. And I am also, I did some dispute reversal cases in Bhubaneswar. So I thought I was interested in getting the arbitration cases in future. Hopefully we will be getting. So that thing is my pleasure. Thank you.
Good morning everyone, I am Isha. I mostly practice on trademarks for last 15 years. I am interested in arbitration to understand and how I can manage my portfolio with arbitration in future. I think there's a lot of scope there. Thank you.
Good morning everyone. I am Advocate Alok Sharma. I have been practicing as an arbitration counsel for the past 10+ years. I am interested in learning few insights about international arbitration. I was junior to Sri Geeta Luthra, who is the Vice President of the Indian Council of Arbitration. She pushed me to come here, so I was in Goa and some other. So thank you.
Good morning, my name is Joy Kumar Jain. I am a chartered accountant at the University of Bangalore and insolvency practitioner. I primarily focus on corporate restructuring, valuations, due diligence reviews, accounting advisory, and I am looking to get into arbitration space.
I am Advocate Prahlad Kachre from Pune. I retired as Additional Commissioner from Sambhajinagar, Maharashtra. But presently practicing in land laws, land acquisition, arbitration. I am deeply interested in ADR because we have practiced this in Kadalat for land acquisition a lot.
Morning everyone. I am Advocate Nisha Nair. I am coming from Kerala. I am a civil engineer turned software engineer turned practicing lawyer. My husband and I, we have an office. We practice together. It's a traditional constitutional matter, civil matter, criminal matter kind of an office. And we saw the advantages of ADR yesterday, reduced time, dispute resolution time, so on and so forth. So looking at those, we thought we'll develop an arbitration practice, especially international arbitration. So as part of setting up the practice, I'm taking the baby steps here. It's a pleasure to meet you all, especially people from different parts of India, and the sessions were also quite interesting. So I look forward to the dinner as well as to our reception. Thank you.
Good morning friends. I am Manikanta Das, a retired chief engineer and secretary. Since 2016, I am practicing advocacy as well as arbitrations. But my knowledge, I think, that not sufficient, although I am doing so many arbitrations. So I joined here. I am a member of the ICN as well as empanel arbitrator of Guwahati High Court. So I come here to enhance my knowledge and experience, to meet all these personalities in this field, to know many things, many more things. Thank you, all of you. Thank you.
Good morning everyone. My name is Purushottam Redekar. I am from Mumbai. I am practicing as a professional engineer, and also I am a member of ICA, and I am doing arbitration as well. I am practicing from last 25 years in this field. Thank you.
Good morning everyone. I am Mr. Santanu Manna. I come from Mumbai Port Authority. I am a civil engineer. And this subject is new to me. Just I have come here to learn. I have no much experience of arbitration. Okay, thank you.
Namaskar friends. I am Mr. Vijay Sonar from Mumbai Port Authority, Superintendent. I am handling the PPP projects in Mumbai, and currently I am handling one arbitration where I have to file the affidavit in reply to the statement of claims. So to get more insight, I came here. I was under impression that something will be covered under the PPP projects also here. Let's hope in the next coming lectures they will consider our request and consider something on that topic so that I can get more knowledge from this course. The subject is very new, but the speakers, whatever the subject handled, was excellent. Thank you very much.
Good morning, everyone. I am Achinto Banerjee from Kolkata High Court. I am a member of the Supreme Court also. I have been practicing for the last 38 years. And I try to venture all branches of law, including this arbitration. Few years back, there was a Goa chapter of international arbitration seminar. I unfortunately missed it despite being applied for because of personal difficulty. That's why this time I didn't miss it. Thank you, everyone.
Good morning, friends. I am Advocate G. Thakur, practicing in Bombay High Court for past more than 26 years. I deal in civil matters plus medico-legal cases. I handled about 10 arbitration matters as an advocate, and I'm successful in all that 8 cases. I thought it's better I increase my knowledge, one, and I can be a arbitrator considering my little more age. So I joined this course. Thank you, sir.
Hello, I am B.S. Chauhan. I am retired engineering chief from Himachal Public Service Department, and I am a practicing arbitrator also. I am paneled with ICA also. I have come here to gain more knowledge from such insightful lectures. So let us hope we gain something more from this workshop. Thank you very much.
Hello, Raj Kumar Verma from Shimla. I am director in a foundation, that is Sai Eternal Foundation. This foundation is undertaking commercial activities to generate the revenue, and whatsoever is the excess of income or expenditure that is being spent for undertaking charitable activities. And we have undertaken a lot of charitable activities in Himachal Pradesh. So we are executing civil engineering projects also. So we have some arbitration cases. So I am here to learn something in this course about regarding arbitration. Thanks.
Good morning. My name is Padya Rajan. I am from Kerala. I am a practicing lawyer from Silvas Partners. We are also doing arbitration matters in Kerala, Bangalore, Delhi, etc. So we are, this is my madam. We are coming to study more than what I meant. So thank you.
Good morning, I am Sujaya, practicing law in Kerala High Court. My colleague is, we are Sinigoras partners already engaged in corporate matters and conducting some arbitration matters also. And this session was very much interesting, but I have a request that if time allows, some more time maybe give us for clarifying our further doubts. Otherwise, the session was very much interesting. Thank you.
Good morning, everyone. Myself, Mr. Suresh Panikar. I am an executive engineer working for Maharashtra State Transmission Company Limited, Government of Maharashtra. My organization, as most of you must be knowing, deals with construction of substations and laying of transmission lines. And day by day, litigation things with respect to laying of lines is becoming a major hurdle for us. And that is the reason why my CMT has given us an opportunity to come here and discuss with you people. Thank you, ICA, first of all, for considering us also, because we as engineers coming and having a dialogue with advocates, learned advocates, it's a great opportunity for all of us. Thank you. Thanks.
Good morning, everyone. I am Bharti Prajapati, working as executive engineer in Maharashtra State Electricity Company Limited. I am the team. This topic is together new to me, but our company also is dealing with arbitration. Our company deals with construction of substation and excess by Sri Panikar. So our management thought that from engineer side also, technical side also, people should go and gain the experience, knowledge of this arbitration. So we are here. Thank you ICA for arranging this.
Hello, myself Arun Unare. I am advocate and retired as IS officer from Maharashtra. After retirement, I registered as a member of Bar Council of Maharashtra Board. Simultaneously, I registered with ICA as arbitrator. In addition, I am independent director registered, and I am working as independent director on one company in Thane as independent director on director board. As well as I am doing agriculture. Being an agriculture graduate, I did take keen interest in farming and the farmer also. Thank you so much.
Good morning everyone. I am Dr. Deepa Singh and I am doctorate in law, and apart from doing practice in criminal law, I teach at various institutions. So as a lawyer, I really experienced that traditional litigation is not sufficient to deal with the upcoming challenges and upcoming cases. So I highly recommend ADR. That is why I have come here especially from Chandigarh to attend. And I would be dealing with these matters onwards in future. Thank you so much.
Good morning all. This is Advocate Golden from Calcutta, High Court and Supreme Court of India. I have been practicing for the last 25 years. We have been dealing as a solicitor for arbitration, other entertainment, media and tax law. This ICA program is also interesting and enriching, and we're looking forward for more information to collect. And thanks to all of you.
Good morning everyone. I'm Tapan Patnaik. I'm from Calcutta. Basically, I'm an automobile engineer and I'm a group CEO of a company. Our company is dealing with automobile industry, hotel industry and the educational sector. So we have two schools under CBSE, and we have automobile, we have Hyundai, we have Mahindra, we have Norris Garage, then we have hotels. So when I am a CEO of this group, I thought this is a great chance I say given to me to understand this arbitration. When we have industry, we have dispute, we have everything. And thanks to ICA, thanks to all the delegates felicitated for this program. I really appreciate ICA for arranging this program, and thank you so much. Good morning. Good morning. Thank you.
Good morning everyone. My name is Advocate Mukul Agarwal. I belong from Calcutta. I had a law firm called Vedam Legal, which is based out of Noida, New Delhi. And they mainly deal in, it's basically an advocate on record firm, and we mainly deal in criminal matters, arbitration matters and tax matters. I am heading Vedam Legal in Calcutta. And I am here with my senior, Mr. Pradeep Das.
Good morning, everyone. I am a senior advocate of Calcutta High Court and former judicial member of Customs Excise Service Tax Appellate Tribunal, Indirect Tax Tribunal, and most of the times I have passed with indirect taxes. Now I am trying to get the knowledge in the arbitration, and my nephew Mr. Mukul Agarwal is with me, and the another purpose to acting this to encourage Mukul to learn this subject. There is a great future in this. That is the. Thank you.
Good morning, Vanna. I am Sunil Agarkar from Vadodara, Gujarat. I represent Taxation Advisors LLP as a designated partner. I am also a director in one other company. I am an arbitrator and also as a district we also represent in arbitration as a concept. Learning is a continuous thing. That is the basic reason that we are here to attend. Thank you.
Very good morning. I am Jaideep Mehta, co-founder and designated partner of District Advisors LLP, Advocates and Solicitors. I am also a qualified independent director and serving on the board of 2 listed companies and 1 private limited MNC company. I am empaneled arbitrator of National Stock Exchange as well as Bombay Stock Exchange through online dispute resolution ODR mechanism, which is recently introduced by SEBI. So those who are not conversant with this, please refer SEBI's July 23 page circular on ODR mechanism. Very wonderful procedure introduced by SEBI, and 1 year they have completed this process has been completed 1 year last in October 24. So it's a wonderful platform. Through this mechanism, I am empaneled with NSE BSE. Thank you, and I am based out of Mumbai.
What the colleague is mentioning is about the 31st July 2023 circular. SMERP ODR. Just Google and find it out. Lot of opportunities that the actors consider and ask you to.
Good morning, ladies and gentlemen. I am Advocate Vedraj Sureskar, practicing before Bombay High Court at Goa bench as well as in Principal Bench at Mumbai. I am a visiting lecturer in Mumbai University also. And I have been enjoying this session where I have been getting a lot of knowledge and insight on arbitration and conciliation. So I am expecting fruitful pleasure for this.
I am Advocate Asha Desai. I am Senior Standing Counsel for Customs, GST. CDI, practicing before the Supreme Court, also on the senior panel in Bombay High Court. And I completed my course in mediation. I tried to do a small study on how effectively the courts can, with the system which is available, with the infrastructure which is available, how it can speedily dispose matters. But since I'm a very, very small person in this whole system, I didn't manage to push that project forward in any direction, I should say. Particularly family matters where we are doing a lot of work for women. We were not able to get even interim orders which were procured by us executed. And so we were looking for some kind of a area where certain courts are designated in Goa. Particularly in Goa, we don't have family courts. So in all this, I thought that yes, we should look at some alternate dispute resolution way, and that's why I'm here to complete and upgrade myself for arbitration as well. Thank you very much.
Yeah, good morning everyone. My name is Sandeep Rajput. I came from Mumbai. I am working in a corporate IFL finance, heading a legal and compliance department. And specifically for the retail, this ODR system we are using on a weekly basis, and we have a lot of cases into the retail where we are adopting all these practices in ODR and ADR, all this. So this is really a very helpful session for us. Thank you.
Good morning everyone. I am Ashok Kabaja. I am a retired chief engineer of JPTOD. I retired in 2023. I am an independent arbitrator of Indian Road Congress and independent DRB of NHAI. I am into arbitration after my retirement. I have 2 cases. I have come here to learn from the studies faculty and the experiences of the participants. Thank you, ICA, for the wonderful session.
Good morning, colleagues. My name is Christabel Alfonso. I am an advocate here from Goa and I practice in courts in Goa and in the High Court. I'm always looking for opportunities to serve the community, and I can see how arbitration and mediation can be a very important tool for resolving disputes. And obviously the first step is to get a training. This has been a wonderful training session from day one, and I look forward to trying something in this field.
Good morning everyone, I am Surabhi Valeria. I am an advocate on record in Supreme Court of India. For me to come back to Goa, and this was a very beautiful opportunity for me because I have done all my schooling from Goa. I am a naval kid, so embodiment of national integration there. So when they were talking about cultural differences being attuned, I think I really enjoyed that because belong to Himachal, born in Bombay, brought up in Goa, so like it's coming back to your roots. So it's an amazing feeling. And when it comes to ADR as a subject, it's very close to my heart because I've done mediation trainings. And in Delhi, we have something called as Delhi Dispute Resolution Society, which is run by Ministry of Law and Justice there. So most of the family matters and the smaller commercial matters, we usually refer it there, and it becomes much easier for the parties to come to a resolution. There is a mediation agreement that they come up with, and then it straightaway goes to the court, mutual consent, and we are done with. So I think the new ventures of ADR, the way ADR is branching out, not considering arbitration as a complete different unit, and coming up with these amalgamation of arbitration, mediation and arbitration, which can be amalgamated today as ADR being a consolidated form of dispute resolution. I think it's an amazing opportunity, and I'm looking forward for Goa to have a chair of international arbitration so that I get my excuses to come back to my roots again. Thank you so much. Thank you.
Good morning. I am Advocate E.O. Mendes from Goa. The field of ADR is not new to me. I have been both practicing, I teach, train, coach and judge students all over the world. So in fact, many of the colleagues here and friends ask me what am I doing this side of the bench. And I said that the purpose is a message to all the lawyers. The future is in ADR and you need a certification. I have 20 from across the world, none from India, accepting mediation. So this is one of the reasons why I came here. It also gave me an opportunity to meet two of the faculty who are old friends of mine, which I need to bump into quite often so that they don't forget that I continue to exist. So otherwise, I'm an internationally accredited mediator and arbitrator.
Good morning, everyone. I am Advocate Vishwesh Kawat from Goa. I am practicing in the civil side, more particularly the property matters and matrimonial matters for more than 30 years. I am practicing in the now primarily in the district court and the lower courts. I have spent this opportunity that was given to us by the Goa High Court Bar Association to have a deeper insight and knowledge on domestic and international arbitration, commercial arbitration is something which is rare. Otherwise, in Goa, we don't come across such opportunities for any training programs as such on a national level. So this is a good opportunity that was provided to us. So I decided to participate, and I understand now the benefits of being here and understanding a deeper, giving a deeper knowledge about the arbitration aspect, which I never thought that this could be so complex. So I understand that this has been made much easier here now for us. And there's one forum where you can have all sort of, you have knowledge as well as you have case laws and deeper studies and discussions on arbitrations, which is only going to benefit us in future. Now, one small incident that I would like to share, maybe a little humorous one, that when I introduce myself to anybody from outside Goa, that I am from Goa, they are like, oh wow, you are from Goa and this and that. But people don't understand that in Goa we work equally. As much as people work in the rest of the part of the country, we don't holiday here all the time. Now if we have to holiday, we have to go outside Goa. So that is what is the tragedy of Goans. Thank you. Thank you for giving me this opportunity of sharing my experience and introducing myself. Thank you.
Good morning everyone. I am Advocate Bhaveshwaram, practicing civil law and arbitration for last 25 years in Goa. Currently I am President of the Advocate Association. I am deeply interested in practicing arbitration, and that's why I joined this course. Thank you.
Good morning everyone. My name is Kishore Kumar from Andhra Pradesh, Amravati. Everyone knows new capital. So I am basically automobile engineer, mechanical engineer with PG ADR from Nalsa. I have acquired qualification. I don't know how to proceed for arbitration profession. That's why he is also one of my friend from Hyderabad. He told me, I said I am going to conduct some training program in Goa. So that's why I am here. So I have 20 years of experience as an independent professional in general insurance claims as a surveyor. One more thing.
We'll ask you to take it little short, just one name and your designation. We can probably take this round later on.
Now I am working as management in general insurance claims in Royal General Insurance Company. Now claims department, legal department, currently working legal department.
Thank you very much.
Good morning. My name is Vakil Srinivas from Telangana, Hyderabad area. Working IRD Insurance Surveyor and Loss Assessor and License Independent Profession. In Department, Motor Department, Engineering and Marine Cargo Claim Settlement in 15 years. Also, PG ADR also Nalsa University is completed. Is joining ICA. Future ADR. Thank you.
नमस्कार, मैं संजय काले नागपुर से हूँ और मैं इंजीनियरिंग पोस्ट ग्रेजुएट किया हूँ और उसके बाद LLM किया हूँ फॉर द इंटरेस्टेड. आई एम लुकिंग फॉरवर्ड फॉर रिजॉल्विंग द डिस्प्यूट इन माय फील्ड, दैट इज सिविल इंजीनियरिंग. थैंक यू वेरी मच.
Avinash Paisai, basically architect, panel and arbitrator on the panel of Bombay High Court. Mainly dealing mostly property related disputes and acquisition cases and other similar disputes, merger, demerger and all that. That's my practice.
I'm Advocate Karishma Diktikar. I'm here to update myself on this topic and finding this session very enriching.
Hi, good morning everyone. I'm Shalvi Singh. I work as an in-house counsel at India Limited, and currently I am majorly dealing with domestic commercial arbitration, which are based on construction disputes and gas sales agreements.
Good morning everyone. My name is Kalin Ganpati. I head a law firm called Lawyers Transcontinental. I have done work across 35 countries until date. I look to join this course to enhance my knowledge in international arbitration. And I have also done a lot of work across India, virtually every state.
Good morning everyone. My name is Harsh Mittal. I am a civil engineer working with Punjab Irrigation Department and Punjab Water Supply Department. I am from Punjab and I am looking forward to enhance my knowledge in arbitration for the contract disputes between construction companies and the government departments. Thank you.
Hi, good morning. I'm Dr. Aruna from Bangalore. I was a professor in archaeology. Now I'm completely with the real estate and property document scrutiny. So probably after this seminar, I'll be a future arbitrator. Okay, thank you.
My name is Kishore Kumar from the state of Kerala. I practice mostly the district courts of Kerala and Karnataka last 24 years. I am more into defenses, civil and criminal law. And I would also like to know more on the procedures in the execution of arbitration, ADR, as well as defenses on the execution of arbitration awards. Thank you.
That's it.
Good morning everybody. I'm Advocate Pritham Marais with 25 years of practice. As you all know, lawyers don't open their mouth unless they are paid for it. I'm from Goa. It's my pleasure to welcome you to the beautiful state of Goa. Thank you.
Good morning everyone. I'm Maria D'Costa, practicing in South Goa.
Good morning everyone. I'm Advocate Astrid Almeida. I'm practicing in the civil law in the entire state of Goa for the past more than 17 years.
Good morning everyone. I'm Advocate Prasad Naik. I'm the President of South Goa Advocates Association. In fact, recently with the intervention and with the help of Bar Council of Maharashtra and Goa, we had this mediation training program under the MCPC. So we have right now in South Goa 30 trained mediators. I am one of them also in that trained mediation which we had done in August. I am thankful to ICA who have tied up with the Goa High Court Bar Association to organize this arbitration so that the second part of ADR is also covered up. So we get more trained arbitrators in the future in the state of Goa. Thank you.
Good morning everyone. I'm Advocate John Montero from Goa. I'm practicing for civil and criminal law. And I'm trained mediators, as my colleague has now said. And I am very thankful to the ICA for organizing this domestic and international commercial arbitration program and we're looking forward to getting the more information in arbitration. Thank you very much.
Good morning everyone. Advocate Madhusudhan Chakraborty, coming from West Bengal. I am practicing civil and law. I have a law firm more than 35 years. Thank you, ICA.
This is Tarun Singh from Delhi High Court, retired last year and trying to learn the law practice again. Thank you.
Hi everyone, I am Rosette Pereira. I'm an advocate in the High Court of Bombay and Goa. I find this subject very interesting, arbitration, from long ago, and I have certainly come across many matters where I have seen there are many loopholes in this subject also. So learning all this is very informative for me. Thank you.
Hi, my name is Advocate Kirti. I'm a practicing lawyer in the state of Goa. It's a great pleasure being here, and after having a little bit of experience, it's always good to learn everything in depth. So thank you so much for this opportunity.
Good morning everybody. This is Lenson Braganza. I'm a practicing advocate, and I'm here as a student of law for an in-depth in arbitration.
Hello, good morning. I am Advocate Vallabh Pangu, practicing in the state of Goa, particularly in the High Court. And I felt that this particular workshop will help me to know more about international arbitration, commercial arbitration act. And I hope that in future also ICA holds such more programs in the state of Goa. Thank you very much.
Good morning everyone. I'm Advocate Sidney Parulkar. I'm practicing in state of Goa. I congratulate ICA for organizing this brainstorming session on domestic and international commercial arbitration. And I welcome you all to Goa. Thank you.
Hi, my name is Sudhir Chala. I'm a principal associate at Resort 360. It's an online dispute resolution platform which I've been working for years. Thank you.
Hello friends, my name is Manpreet Singh. I'm Advocate Manpreet Singh, practicing at Delhi High Court, and I'm very thankful to ICA for inviting me here for this event. Thank you.
Good morning everyone. This is Advocate Sonali Navdekar. I practice in the state of Goa. And I am thankful to the High Court Bar Association for allowing me to participate in this event.
Hi, I am Charan. I practice in Goa. I welcome all our fellow colleagues who have traveled all the way. I thank ICA to do this in Goa, and I hope you make this a permanent destination.
Good morning everyone. I'm Bernard Fernandez. I'm a practicing lawyer in the High Court of Bombay and Goa. Thank you ICA for doing this certification course, and I think there's one last person.
Good morning everyone. I'm Advocate Chirag Niklaucha. I practice in Goa as well as Nagpur. Thank you High Court Bar Association of Goa for such a good initiative, and thank you ICA also. It's a step in the right direction and at the right time. Thank you so much.